please the board. We're here today on my name is Jacob Phillips. I represent the plaintiffs and appellants in this case. And we're here today on allegations of a breach of an insurance policy where the plaintiffs alleged that the defendant, Allstate, failed to pay the actual cash value or the market value of their vehicles, which have been in a total loss. There are essentially two critical questions here today. The first of which is whether this court's decision in the Cslty v. Elephant case is applicable to Allstate's policy. And the second of which is whether the market value of a motor vehicle is a question of law or a question of fact. For purposes of oral argument, unless the court directs otherwise, I'm going to go ahead and kind of skip the first question and focus on the second one, which kind of assumes that the Cslty case is applicable, and ergo, one of the claims that the plaintiffs brought, which had been for taxes and fees, is foreclosed by the Cslty opinion. We gave an argument as to why it's not, but I'll skip that, jump to the second question, which is whether the market value of a motor vehicle is a question of fact or a question of law. Now, this court's Cslty opinion answered the question. It said that the market value of a vehicle is certainly a question of fact. Texas Supreme Court law, consistent with that proposition, goes back, from what I can tell, to 1931, which was the first case I could find that said that the market value of an automobile was a question of fact. In the Fifth Circuit, this court confirmed that as recently as last year. Now, what the plaintiffs had alleged as a factual matter was that the defendant underpaid the market value of their vehicles. They alleged that their vehicles, the market value of their vehicles was $700 in one case, $800 in the other, higher than the amount that the defendant said that it was and the amount that was paid by the defendant. Obviously, the defendant disagreed and said, no, we're right, the market value is $800 less than you think it is. That's a factual dispute. It's a factual dispute requiring evidence. It's a factual dispute to be resolved by a jury. The plaintiff even sort of put forward the evidence that they—
Will that cut against your class certification theory then?
I'm sorry?
I assume that'll cut it. Class certification is not here, but that sounds like that's a good argument for reversing this in this appeal, but then defeating class certification.
Correct, right. So the order on appeal reads kind of like a denial of class certification, right? It's at least the beginning of it, where it's saying, no. The legal theory that the plaintiffs proffered, which was relevant to class certification, was that the insurance companies essentially have to use evidence of comparable sales. Maybe that's true, maybe it's not. The plaintiffs believe that it is. The court below believed that it was not. That theory, though, is only relevant to class certification, right, in the sense that—
So if we may, let's talk about this comparable sales.
Okay.
I find that sort of interesting. Aren't both sides using comparable sales? And the question is just what your specific comparable sales methodology happens to be?
No, so what Allstate is doing is that they're taking, say, 8 or 10 comparable listed for sale vehicles, right?
So sales offers.
Exactly.
As opposed to actual sales.
Exactly, and then they are—
Although what's interesting about that is sales offers would presumably be systemically higher than actual sales as parties bargain and negotiate. I'm not sure that cuts against your argument, but it is curious.
Yeah, so, and what Allstate does is they take those offers and then they do lower them by guessing what they think the seller, in that case, will actually accept for that vehicle.
Oh, I see.
Yeah, okay. And so what they're doing is saying, okay, we have these offers, to your point, people can negotiate, right? This is Allstate's theory, and I disagree with it for reasons I'll get into in a second, but the theory is, yeah, sure, they're offering it for that, but there's always negotiation. We're guessing that they'll accept $900 less or $1,000 less or whatever the case may be. Now, what the state of Texas, ironically, publicly available for purchase, the state of Texas posts the amount that every single vehicle in the state is sold for, right? And so we don't have to guess. We can just find out what those vehicles sold for, right? And so that's kind of the theory behind— that's plaintiff's theory, is that, listen, you don't have to guess. The amount is actually there. You can just actually find out what these vehicles are being sold for. You don't have to guess. And we provided a few specific examples. In one case, Allstate guessed that a vehicle VIN number would sell for $12,000. That exact vehicle sold for $14,000. They guessed wrong, And the point being that that's the reason why, for instance, in the real estate context, the Supreme Court of Texas has said you can't use comparable sales from 300 miles away if there's comparable sales in the vicinity, right? Like you can if there's not any comparable sales in the vicinity, but if there are, use those. Don't use the ones that are 300 miles away. plaintiff's theory is even more fundamental than that, which is that if there are comparable sales at all, use those, don't guess. That's kind of the whole point. In the court's opinion in Singleton, that was the theory behind rejecting that you use replacement cost less depreciation, right? Which was the allegation from the plaintiffs in that case, is that market value in the context of an ACV policy is measured as cost less depreciation. And the court explains, well, why would you have to use that? If it used automobiles, you can determine that by going into the marketplace and finding out what they're being sold for. If you can do that, why do you have to use this cost less depreciation? You don't have to, right? That was sort of the court's opinion. What plaintiffs are saying is that if you can go into the marketplace and find out what these vehicles are being sold for, then you don't have to guess. You can just find out, and Texas makes it available. But now the point is, all of that is honestly relevant to class certification, right? Because if Allstate is permitted to use this method that they're using, they just have to do so accurately, right? They're allowed to guess, so long as they guess correctly. Then, for purposes of class cert, you'd have to go through each and every single individual vehicle and find out whether they guessed correctly or whatever. Like, that would presumably preclude the ability to certify a class, right? So plaintiffs gave that legal theory to show why the class is certifiable. Let's assume that they're wrong, though. Let's assume Allstate can use the method that they used as like a legal matter, right?
What do other insurers use?
I'm sorry?
I was curious as to what other insurers in Texas are using, USA and various other insurance companies. How do they, in terms of the industry and the market itself, move away for a moment from Allstate? Which of those companies are using the methods that you're advocating?
So insurance companies generally do not use comparable sales.
Is any of them to use it? What you're advocating? Is what you're advocating in play in the market at all or not?
So a lot of insurance companies do not make the adjustment. They don't make the guess, right? They take the comparable vehicles and they just use whatever it is that it's being offered for, right? Some insurance companies, including Allstate, then take that number and guess at what they think it will actually sell for. I'm not aware of...
The direction of my question is this, your litigation is with Allstate. My question, though, is we're trying to identify a contract term, but that contract term of loss is, it obviously appears in all the other insurance contract. And my sense is, what is the impact of what you're saying upon the industry itself? Are we talking about only Allstate, or are we talking about some universal change in cost?
The insurance companies of which I'm aware do not use comparable sales, what plaintiff is alleging they need.
And none of them use it?
I only know of a few, but yeah, I'm not aware of any that actually use comparable sales. I don't think the impact would be very significant, though, for reasons that most insurance companies, for instance, Geico, don't make the adjustments. They don't make the guess, right? So they might use offers rather than sales. But to Judge O's point, the offer is the ceiling, right? So if you use the offer, what's the damage? Like, let's say this court were to...
Your point is these other insurers pay systematically higher than Allstate. That's your theory.
The ones that I'm referring to, I honestly, I don't know what every insurance company does, but like Geico and USAA, for example, are two that I am aware of. They use the offer, so they don't use the sale, which is what plaintiff is saying. But the offer is the ceiling. Nobody comes in and says, hey, you're offering that car for $19,000. I'd like to pay you $20,000. So I don't think the impact of saying you have to use comparable sales would be particularly significant for the insurance companies that use the offer, which is the ceiling, rather than the insurance companies like Allstate that then reduce from that because they're guessing at what they will actually sell the vehicle for. But again,
what does the Texas Supreme Court tell us on this question? Other than, as you noted, that this is generally a jury question, has the Texas Supreme Court specified what the guideposts are for juries?
They have.
What methodologies are allowed, what are not allowed?
They have, and there's two components to that. The first is, as this court noted in the Singleton opinion, if you can find out the market value based on sort of comparable sales, use that. Don't use cost less depreciation, don't use intrinsic or subjective.
Okay, but again, both sides are using that, so we're getting into sort of a more granular level of the analysis.
Okay, correct. So then...
Let me cut to the chase. Has the Texas Supreme Court told us which of you is correct?
There's not a case directly on point saying that you have to use actual sales
So should we certify this question to the Texas Supreme Court? It seems like it's hard to make an eerie guess here.
So here's, okay. So first, I don't actually think that issue is before the court yet. So in other words, the question of whether they have to use comparable sales. The only question before the court right now is whether plaintiff's allegations that Allstate undercalculated the market value of their specific individual vehicles is plausible. That's what's facing the court right now. So you would have to be—
Right, but you ultimately want to get to a jury. That's the whole point of this exercise, right? To defeat 12b6, defeat summary judgment, get to a fact tribunal.
Correct, but even if—
So the question is, what is the legal test that we're going to send to a federal jury? How can we make that eerie guess with essentially no direction from the Texas Supreme Court?
Well, so let's say that the question of whether you have to use comparable sales, as plaintiff alleges as their legal theory, versus offers and guesses as is Allstate's theory, let's say that was certified to the Texas Supreme Court, their answer to that question wouldn't be dispositive of even the individual claims of the plaintiff. They could say yes or they could say no, and it wouldn't really matter because then it would come back and then it would just be a question of whether a jury buys the evidence that plaintiffs have versus the evidence that Allstate has. What the Texas Supreme Court has said is that if you use comparable sales, they've been given guidance for what you use, right? It has to be in the vicinity, it has to be similar, it has to be whatever the case may be. Plaintiff would go to a jury with their evidence, Allstate would go to a jury with their evidence, and they would resolve the individual claims. The only reason the legal theory that you have to use comparable sales is at issue is for purposes of class certification, which is not facing the court. And
Let's say both sides, I can imagine a jury seeing the evidence on both sides and thinking, well, these are both reasonable arguments as to what actual cash value is. What is the legal principle that that either the jury or the judge or an appellate panel is supposed to apply to that situation?
if a jury—
Seems like Texas Supreme Court hasn't told us what the legal theory is.
and they've said it's a question of fact to the jury. So in other words, you're correct. Presumably, to survive summary judgment, both sides would have had to have presented reasonable evidence. That's why we—
So one jury could side with Allstate, another jury could side with you, and that's just the state of insurance law in Texas?
Well, as for the specific question of what the dollar amount of a vehicle is, sure. Now, there's a lot of policies—
No, I meant the methodology. There are two different methodologies here. Presumably, insurance contracts don't vary based on which jury you get. The insurance contract says what it says.
So presumably, the methodology would— Allstate would survive summary judgment, let's say, and not have a class certified, let's say, because the court were to hold as a matter of law that they're permitted to use the methodology. The methodology itself doesn't breach the contract. The question is whether the methodology as implemented for plaintiff's claims correctly identified the market value.
Well, let's move it to an actual trial context. So we assume we're in federal court and the Rule 49 submissions, and the question is put to the jury: what sum would do you find would reasonably compensate the plaintiff for its losses? And considering those costs, what state law? What are the state law requirements for completing that instruction to the jury? In other words, these cases are tried routinely to juries, and usually with cost of lost automobile incidental to some larger injury, etc. But that's when push comes to shove. It's what you tell the jury as to what they can consider. But it comes earlier in the case as to what evidence comes in, of course. And so I'm trying to figure out. We're talking about Allstate here, and so exactly what are the state law guiding principles here?
So the evidence that the jury— that's a great question. The jury wouldn't be presented with a question of whether—
Yeah, please don't step away from the mic.
Sorry?
You're backing away from the mic.
Sorry.
My hearing aids are very old.
So the jury would not be— this question is connected to the previous question in the sense that the jury would not be asked, is Allstate's methodology permitted under their policy, right? Because that question is a question of law, a question of contract interpretation that the trial court presumably would answer. If it got to the jury, it would mean that, sure, as a matter of contract interpretation, the methodology that they used is fine so long as it ended in the correct result, right? So then the evidence that the jury would be considering is plaintiff's evidence of comparable sales of vehicles in that area showing that the market value is $13,000, whatever, pick a random number, versus Allstate's evidence of their third party's guess as to what those same vehicles actually would have sold for. The jury.
But what's the legal principle? You previewed my question exactly. I mean, you say it's got to be the same county, same month. Allstate says it doesn't have to be. You say it's got to be actual sales. They say 3 to 10 comps based on offers. I mean, are those all jury issues, or is there a correct legal answer, and we just don't know what it is?
There's a legal answer as to whether you have to use comparable sales, which plaintiff says that you do, or whether you.
Right, but again, both sides use comps.
Well, but they don't. So the legal dispute of contract interpretation is whether you can use offers and guesses. Here's an offer, but
Right.
guess itself.
Okay, exactly. Is that a legal question or a fact question?
That question, whether you have to use offers and guesses or actual sales, is a legal question.
Okay, and who's right, and what is the Texas Supreme Court case that tells us who's right?
The Texas Supreme Court, I believe that plaintiff is right, obviously, and the reason.
I understand that, but at the end of the day, this is a question of Texas law. We're supposed to guess.
The Texas.
How can we guess when there's no law? Why don't we just certify this and find out what the law is?
So going back to why we don't certify it is because, again, I don't believe that that question is facing the court right now, because it's irrelevant to the question of whether plaintiff's individual claims are plausible. Plaintiff's individual claims are that the market value of their vehicle is X, and Allstate.
Well, but if the Texas Supreme Court had told us Allstate is absolutely correct in every single legal methodological question they're addressing, then that would be dispositive of this appeal. And likewise, if they had said that you're right and Allstate's completely wrong on all these issues.
I do not believe that if the Texas Supreme Court said that Allstate's allowed to use the methodology, that it would be dispositive of plaintiff's individual claim. And to use a crazy hypothetical, let's say that it was legally permissible for Allstate to pick a number out of a hat, right? They would still have to pick the correct number out of the hat. So in other words, yeah, sure, it doesn't ipso facto breach the contract to pick a number out of the hat because.
Right, but if your complaint stipulated that they picked it out of a hat rather than out of a shoe, then you would lose.
No, here's what I mean by that.
Okay.
I have a Honda Civic, right? Honda Civic is, let's say it's 10 grand or something, approximately. Allstate is allowed, technically speaking, from a legal perspective, it does not ipso facto breach the policy for them to pick a number out of the hat. As long as they pick 10,000 out of the hat, right? Or like they can't, to say that you're allowed to do a methodology legally is only to say that it doesn't, in and of itself, breach the policy. But that method still has to accurately identify the market value, the factual market value of the vehicle, right? So if they pick 10,000 or higher out of a hat, sure, it's not a breach of the contract. But if they pick $1 out of the hat, the market value of the Honda Civic is not $1. So just because they're allowed to use that methodology in the sense that it is not by itself, ipso facto, a breach to use this methodology, does not answer the question as to whether that methodology was accurately implemented as to a specific vehicle, which is why the individual claims facing the court right now don't turn on the legal question of whether the methodology itself was a breach. The district court, that was the problem with the order, is that the district court conflated the two. The district court
Your initial time now has expired.
I am so sorry, Your
Phillips,
Honor.
and that's okay, you saved some time for
I
rebuttal.
will reserve the rest for.
All right, Mr. Higgins.
May it please the court. Roger Higgins on behalf of, excuse me, Appellee Allstate Fire and Casualty Company. I want to point out that we're here on a motion, an order granting a motion to dismiss under 12b-6 based upon the actual pleadings that the plaintiffs filed, the third petition that they filed in this case. And before I get into each of those, so I want to point out that on each of the 4 counts, the court was correct in grounding the 12b-6 motion. On the original count, with the original claim, had to do with a basic claim that Allstate had to pay an additional amount of money for sales tax and license fees. We know under Singleton and the policy language, that's not appropriate. They've almost conceded that. With regard to the second count, that is the primary substantive count here, plaintiffs have actually alleged that we are required to use a certain methodology, and that because we did not follow that methodology they call comparative sales, we breached the contract. The court properly dismissed that as well because that's not founded under the contract or Texas law.
Well, does Texas law say that this is a jury question?
Not that question, not the question they pled. The question they pled was that it's on that as a matter of law we have to use comparative sales. The question.
What's the Texas case that says that they're legally wrong?
I'm sorry?
What's the Texas authority that says that they're wrong as a matter of law?
Well, let's start with Singleton. In Singleton, this court said that when you're looking at actual cash value is a term that is not ambiguous, and it has a meaning that can be ascribed to it, and that meaning is fair market value. And in Singleton, the court specifically addressed the issue of the broad nature of evidence that might come in determining fair market value. There was no holding that comparative sales was required. In fact, the discussion in the paragraph of Singleton where they are talking about the Felder case and the Sarbonneau case, it was very clear that there's a broad range of evidence that can be considered in addressing the question of—
Are you saying that plaintiff's theory is legally impermissible to a jury, or that it's not legally required of a jury?
Let me answer the question this way. I believe that Judge Higginbotham asked the question of how would this be presented to the jury? Well, there's a pattern jury charge. And the pattern jury charge, when you're asking about actual cash value, talks about market value, which is what a willing buyer would pay a willing seller. I'm shorthanding a little bit, but it actually picks up exactly the definition that—
Let me just cut to the chase. Aren't both sides presenting different theories of what actual cash value and market value is? Those are things that estimators famously disagree over. Is the point that is that the jury could pick between either of you guys? Or is there some legal reason why they have to pick your theory?
I'm sorry. There's a broad range of what they could consider. Could they consider, is comparative sales some evidence? Is other information? What the question is that's being posed is not how we approach the adjustment of a claim. The question that is posed is, what was the value of that vehicle, Miss Cody's vehicle, on the day of the accident? Not what some comparative number is or anything. That's about how claims are adjusted. That's not the contract. The contract tells us to pay actual cash value, which is market value of that vehicle on that day. And that's how the jury is inquired. What is the value of this vehicle on that day?
Right, so you have one number, they have another number. Your number comes from one methodology, the other side's number comes from a different methodology. If they disagree with you, don't they go to a jury?
They could go to a jury, and then other evidence could come in, like an expert.
Okay, so this case should go to a jury then?
Pardon me?
So this case should go to a jury?
Not this case, not the way it's pled, Your Honor. Because this is we're here on the fact that they did not plead. They did not plead. I think it's really important to understand what the plaintiffs pled here. This is what they pled. This is paragraph 3. Texas law requires the ACV of a damaged property be measured either as replacement cost less depreciation, Singleton threw that out, or based upon comparative sales. In contravention of such requirement, defendants utilize neither method. There is no method mandated by Texas law, by Singleton, the Texas Supreme Court, or otherwise. And if you look at the actual—
There's nothing that's mandated. All of these are permissible. It's up to the jury.
I'm sorry.
Let me speak up. I get that your position is nothing is mandated. I think they actually agree with that. I think their point is all of these are permissible. It goes to a jury. So if it goes to a jury, it goes to a jury.
They could have alleged that. They didn't. In their pleading, which was what Judge Kincaid was addressing under our 12b6 motion, they pled, for instance, in the count that we're addressing, this comparative sales count, they alleged that defendant's failure to utilize the comparative sales approach breached the contract with plaintiffs and every member of the class. And they alleged in that same count that we're required to use that. That was their allegation. They didn't allege an iota about we didn't pay actual cash value. They said we didn't follow the approach, and that's why Judge Kincaid properly dismisses.
Well, I mean, come on. That's their whole theory. The case is that you haven't paid actual cash value.
No, it isn't. Their theory of the case, the way they pled it, it's not. Now, in Iqbal, which is the basis for a 12b6 motion to dismiss the Supreme Court decision, they said it's not good enough that you come close to an allegation. It's not good enough that you have a possible allegation. They could possibly plead anything about actual cash value, but they didn't. What they did plead was that we are required under our contract in the Texas law to only pay by comparative sales. That is not what our contract says. Texas Supreme Court has said the actual language in our contract is not ambiguous. The actual language, that was the Schaefer, American Manufacturing versus Schaefer case back in 2003. The Texas Supreme Court addressed that and said, you will not splice additional meaning onto this contract. You cannot do that because it is a unambiguous contract and it's the actual language that we have in our contracts. And they said, so what they're trying to do is have this court, this federal court, come in and
Is your
tell us,
view, is your view this, if they had just replet it and instead said the following, Allstate offered my client X, we want X plus 1,000, that would go to a jury?
I think they would have to say that was not the actual cash value and they breached their contract.
Right, exactly. That would go to a jury.
That could possibly go to a jury.
So the fact that instead of using numbers, they talk about a methodology that leads you to that number, that's somehow the pleading defect?
The pleading, this is a serious pleading defect because they say the breach is not what we paid, but that we didn't use that method. And they're asking this court, this federal court, to write into the contract a provision about how these claims should be adjusted that don't exist. And obviously, this case has been around since 2019. It started out as a class action asking for sales tax and fees. It didn't work. Singleton threw that out, and they were trying to ask the court to splice on a methodology there. That's what they call the replacement cost minus depreciation methodology. So what they did was, and they're kind of throwing this back on the judge. He's really looking at the class issues. No. This is kind of a mirror argument. What they wanted to do was have a class action. So they pled this very tightly to say, you didn't adjust this right. Texas law requires you use this one theory. They pulled it out of a case, Sacred Heart, and said, it's in there. It's not. And they said, this is mandated by Texas law, and you didn't do it, and that's why, therefore you breached your contract. They didn't say, you didn't pay us enough under the contract because the actual cash value. They could have pled that, they didn't. And as the court recognized—
Instead, they pled that your methodology underpays them.
No, they actually pled that because we didn't comply with the methodology, that we didn't follow that methodology, we breached our contract. They didn't even say that we didn't pay actual cash value. They said that we didn't pay in accordance with their theory, legal theory on this. And this is very much like a case this court handled about 15 years ago called, Sonier versus State Farm. And in that case, the theory was, well, we got auto policy requires repairs. And the plaintiff's theory was, we want a class action, so we're going to say you should always inspect the seat belts. And we're going to add that to the claim. And the court here properly said, look, you can't add obligations to the contract, and we're going to properly dismiss this case under 12b-6. And so under 12b-6, the court said, you know, it's always possible that seatbelts could have been repaired or inspected, and that factually could be the case. Just like here, it could be the case we didn't pay actual cash value in accordance with the definition set forth in Singleton and in the state other cases in Texas. But what they said was no, but they didn't do that. It was obvious they were trying to seek a class action, so they came up with this across-the-board ruling.
Mr. Higgins, you need to stay right in front of the microphone bar there. It's not your fault. We just always have audio problems in this courtroom. So.
And in Sonier, the court properly said, look, just because they could have pled that this was actually the case doesn't mean it. They pled that this was an obligation in the contract across the board. They're wrong, and we're properly dismissing the case under 12b-6. And I think it gets back to what we're really trying to do in a 12b-6 motion. This was the third pleading that they filed in this case. And in this pleading, they added this comparative sales argument that we had to follow comparative sales. And in that situation, there is no Texas law that says you owe comparative, that's how you have to adjust the claim or that's how we have to pay the contract. There's no Texas law, there's no provision in the contract, there's no Texas case law that says that, and there simply is no merit to their position that failing to do that breaches the contract. So the court looked at it under Iqbal and said, look, this is not facially plausible. The pleading alleges very specifically that we breached the contract because we didn't follow a specific methodology. And what they want to do is come in and say that applies across the board, and that was the theory because they really wanted a class action. Just as he almost admitted here, if I go to just, you didn't pay enough under actual cash value, you didn't reach market value, and all the evidence that's appropriate can come in, I don't get a class action. He pretty much conceded that in his argument. And so it was the plaintiffs that were trying to restrict this case to the point where they could create a common issue. And so I reviewed this petition, all 100+ paragraphs, and it's entirely based on, you have two methods that you have to follow: replacement cost minus depreciation or comparative sales. You didn't do it, and you breached your contract. And that's exactly what Judge Kincaid obviously relied upon in determining that they had not pled a legally sufficient claim so that the court could reasonably determine that we'd be liable. Because if we fail to file the comparative sales approach, whatever that is, doesn't mean we breached the contract. That doesn't establish one bit that we breached the contract. It doesn't. And if really what they're talking about is different kinds of evidence, but that's not what they're approaching. They're saying it's a mandated rule. So as we go through each of the counts, count 3 is the original count that's been here all along that was dispelled by Singleton. I think they've all but conceded that. It's very clear that the judge the court properly granted the 12B6 motion on their count 3, which is what they call their cost approach count. On the comparative sales approach count, which is what they call it, the court properly granted that because their allegation is that we were mandated to follow that and we did not follow it. With regard to the declaratory judgment count, the court properly granted that because it fails with the other two. And then on the prompt payment account, under the Barber Technologies account, the court properly granted that count. But I do think that the court has focused on the issues that the plaintiffs are trying to raise now after the fact. But what we're addressing is the actual pleading, not what they could have filed, but what they did file. And in Singleton, in American Manufacturers versus Schaefer, it's very clear that if you pay the actual cash value, which is market value, that's what the standard is in Texas. There is no comparative sales standard that sets up a requirement. There was an inquiry whether this case should be certified to the court. I think this is a made-up issue to create a class action opportunity. I think it's an opportunital issue where they picked a paragraph out of a footnote in Singleton, which wasn't even talking about the proper methodology. But if you look at the paragraph in Singleton, it talks about the broad kind of evidence that is permissible.
Right. So I've taken a look at Saunier, and I'm aware of Singleton since I was on the panel. In both of those cases, there's a legal theory that the court found legally foreclosed, that it could not be sent to a jury. Is that what you're saying here, that their methodology for actual cash value cannot be accepted by a jury?
I think that if they are saying that our contract requires it, they're wrong. If it's just...
Could a jury agree with them?
Jury could not, it would not be up to a jury to conclude what our contract requires. That's a question of law. Actual cash value is...
Okay, so what is the Texas legal authority that says their reading of the term actual cash value is wrong?
It is that, well, first of all, Singleton, Dawson, all the cases that address what actual cash value means, which means market value, just simply the market.
I think everybody agrees it's market value, and everybody agrees that you look at comparable sales. The question is, which types of comps do you use? Sales, actual sales offers, same county, same month, all that sort of thing.
You can use that. You can use testimony from an expert who is familiar with the marketplace, but also trends in the market, things that are happening, you know, how flexible people are on their prices in a market, economic factors that might impact things. As this court recognized by referencing Sarvino and Singleton, there is a broad range of things that might come into play in court. Now, if we were to adopt their theory, kind of turn it around on them, if we were to adopt their theory, we couldn't get it out in any evidence other than comparative sales. That's what their case and that's what their pleading is based on. And that's essentially what they've alleged in their pleading. We have no ability to introduce anything other than comparative sales. And that is simply not the standard under Texas law. And so asking about how we do it at the trial court is a good question because it underscores just how wrong they are.
But could a jury say, you know what, I've heard all the evidence, everything you're talking about, and I think actual cash value is what the plaintiff's theory provides for? Are you saying that that should be reversed as wrong as a matter of law?
The jury should not be asking what the standard is. They should be instructed on what the standard is, which is what the market value of that vehicle was on that day, that vehicle. The question to the jury isn't, what are cars like that going for? The question that is presented to the jury is, what was that car worth? And so it's a broad range of evidence that might come into play.
And if the jury were to conclude in answering that question, plaintiff's evidentiary presentation makes more sense to us,
Sorry.
would that be wrong?
I'm sorry, I didn't quite hear you.
So we all agree it's fair market value. The problem is fair market value can be determined through any number of methodologies. I think that's your point. If a jury were to take the plaintiff's presentation of fair market value and say, that seems reasonable to us, we'll side with the plaintiff, would that be wrong as a matter of law?
It's not about the methodologies. It's about the evidence that's presented. And so if the court were to come in and say, I will only allow you to use a comparative sales method, that would be narrower than the actual cash value definition. That would be restricting the evidence to be permissible, and therefore that wouldn't be appropriate as a matter of law. So the question in this, again, going back to the pleading, how they pled it.
Let's say an insurer said, I'm going to use the 10 lowest comps in the relevant pool. Plaintiffs say, we want the 10 highest comps in the relevant pool. What should a jury do in that situation?
Well, you're going to hear testimony from the plaintiff on what their car's worth. You're going to hear other testimony. And a good lawyer is going to bring in a great amount of detail about that individual car.
Let's just take my hypo, though.
I'm sorry.
Let's just take my hypo. The plaintiffs present the average of the 10 highest comps, and the insurer provides the average of the 10 lowest comps. That's it. That's the entire record. What should the jury do?
Well, I would be concerned about that. I really would think they would look at the vehicle and the pictures of the vehicle and other information about the vehicle and try to determine what the value of that car was.
So they should ignore the 20 comps and just come
I think they can if they have other information.
Right. So in other words, the jury has a lot of flexibility here.
Yeah. Okay. Yes, Your Honor. Sorry. All right. I see I'm about out of time. I would urge the court again. It is what was facially plausible is the standard. Not what they could have filed, but what they did file. And they claim that we breached our contract because we did not follow a precise method that is not mandated by the contract or Texas law. Thank you.
All right, thank you, Mr. Higgins. Mr. Phillips, you've saved time for rebuttal.
Thank you, Your Honor. I'll keep this very brief. We believe that it's pretty clear that our complaint is that they did not pay the actual cash value of the vehicle. That's the whole point of the entire complaint. If there's a replead and specifically say these magic words, maybe. And then I'll just point the court to two cases. The closest the Texas Supreme Court has come to adopting the plaintiff's theory that you should use comparable sales if comparable sales are available is the Bluestone case, Bluestone v. Randall, 620 Southwest 3rd, 380. What they held is that the preferred method of determining market value is by using actual sales. And that was what they were distinguishing that was not offers. They were distinguishing the cost less depreciation or the income capitalization or intrinsic value or subjective opinions or whatever. And they said, no. Preferred method is comparable sales. Required method, not quite, but that's as close as.
But that's sort of my point, right, is the Texas Supreme Court deals with this. This is Texas law. They will answer these questions. Why not certify this question to them?
And I would just repeat what I said before, which is that on a Rule 23F petition where that theory is actually at issue? Perhaps so, but here, the sole question facing the court is the plausibility of plaintiffs' individual allegations about the market value of their vehicle, which does not turn on whether they're required to use comparable sales or not. To your point, even if they're not required to use comparable sales, we can still present that evidence to a jury, and the jury can find our comparable sales more persuasive than defendants' guesses, right? So whether they're required to use comparable sales is not yet facing the court.
Right, but your point is the insurer's theory, maybe your theory is not required, but you're saying their theory is forbidden. That's a question of Texas law.
But whether plaintiffs are correct on that point is not dispositive on the appeal right now. Whether plaintiffs are correct that the insurance company is required to use comparable sales does not control whether their allegations are plausible that the comparable sales are more persuasive evidence. So that question, whether they're required to use comparable sales, is not yet at issue. It would be at issue for purposes, again, of class cert. If the court were to grant class certification because they bought plaintiff's theory that you're required to use comparable sales, right? Allstate presumably brings it up on appeal, saying the court got it wrong, we're not required to use comparable sales. At that point, the question of the legal question would be at issue. Right now, though, plaintiff's allegations are plausible whether or not they're required to use comparable sales, because even if they're not, we're at least required to present the jury with that evidence and see if the jury likes the comparable sales more than they like the guesses from Allstate. But I agree, Texas Supreme Court, there's no dispositive case on that point. The closest is the Bluestone case where they said it's preferred, but didn't say that it's required. Unless there are any other questions, I appreciate it, and I'll rest there. Thank you.
Thank you, Mr. Phillips. Your case is under submission.